Hi, all. Thank you for attending today's webinar. Before we begin, we wanted to cover a few administrative items, and I promise this will be the only time today I read off of something, but I want to make sure y'all get your CLEs. If you have any questions during the webcast, you can submit them through the Q&A widget. If I will try to answer the questions during the webcast, but if a fuller answer is needed or if we run out of time, I'll try to answer it later via email. If you experience any technical difficulties, though, during the webinar, those can also be reported through the Q&A widget, and we'll work to resolve your issue that way. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can also find additional answers to some common technical issues located in the help widget. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional attorneys. CLE credit is awarded based on full attendance. To verify engagement, secret words will appear in multiple choice polls during the webinar. Please respond to these polls to receive full credit. We value your opinions and appreciate your participation in the course. So with no further ado, we will start today's session on labor and employment updates for government contractors. This is really intended to be an overview of what happened in the last year. For those of you who work with the federal government a lot, you know that the government fiscal year runs October 1 to September 30th. So the idea was to cover updates that occurred during that time, because that's kind of the cycle the government follows in pushing through updates, which we tend to see a lot of updates come through in September. And I think you'll see that was true for some areas of this work as well this past year. Obviously, I'm not going to spend a lot of time on this slide, but I did want to note, for those of you who have been attending a lot of our Being Resourceful webinars, you'll probably note that I'm one of the few presenters who doesn't really identify as a labor and employment attorney. I regularly do work with our firm's HR group because of the intersection of HR and government contracts, but I really am a government contracts attorney working with government contractors and federal grant recipients. And I think you'll see how that comes into play with my work, as well as that intersection of HR and government contracts in what we talk about today. And just to give you an idea of what we'll be talking through today, if you registered, this list should sound very familiar to you from the registration page. I'm not going to read the slides verbatim as we go through today's session. I've tried to put a lot of information on the slides to help folks as a resource later. And that includes a fair number of instances where I've quoted language from executive orders, laws, cases, those kinds of things. But I will also try to give some more practical information and tips during the discussion of the various slides. And so that may mean you might find it helpful to take notes as we go through the slides, but it will also help ensure you get your CLE credit. So as I mentioned, the first thing on the agenda slide is some level setting. And this is really just to help folks who aren't as familiar with the government contracts regulations. And I think it's helpful to do this, particularly this session, given some of the changes we've seen in the government contracts world, as it might help folks who are more in the HR realm address some of these questions they may be getting. So I wanted to start off with some background for attendees who truly aren't that familiar with the FAR, or what's known as the Federal Acquisition Regulation. This should provide some understanding of the history and the operation of the FAR. And I'm not going to read through all of this verbatim. It's really here to help folks as a reference and a resource during today's discussion, as well as you later may need to review materials. But I think some key takeaways for folks are going to be that the FAR has a long history and it's not a recent creation. I mean, it was a bit of an April Fool's date that it came out back in 1984. So it's been around for a while. But even before 1984, there were other regulations that governed what now is governed by the FAR. So there's been a long history of regulations governing federal acquisitions. But another takeaway is that the FAR governs actions from the procuring agency. So these are things in the FAR are items that the procuring agency looks at and must take action and do. It doesn't really apply in the same way to other agencies who may also be involved in enforcement of related topics. An example of that is the Small Business Administration has a role in government procurements and government contract rules where there are small business preferences. The Small Business Administration's role is not really addressed in the FAR. It is to a small degree. Relatedly, and more importantly for today's topic, the Department of Labor also has a hand in government contracts rules involving labor and employment issues. So that means there's going to be some things that are addressed in the FAR based on what the purchasing agency has to do. And then the Department of Labor may also have its own regulations that it issues on a very similar topic, but related to its enforcement. So contractors may need to be aware of both how the FAR and the Department of Labor regulations address the same topic. This means that there's also a lot of intergovernmental coordination, and we have the FAR Council, which you'll hear later today about how that council plays a role in the regulations that come out as part of the FAR. Something else that I thought may be helpful for folks who aren't as familiar with the FAR is just going through a little bit of how it's organized. Really, it's helpful to know that it's just organized into parts and subparts. FAR Part 22 is the one that's probably most relevant to the folks who are attending today's session. It deals with the application of labor laws to government acquisitions. So most of the issues that could come out as part of labor and employment questions for government contractors is going to be addressed in FAR Part 22. But then the solicitation provisions and contract clauses that the government uses to implement the regulations that apply to it are going to be found in FAR Part 52. And the way the FAR is organized, all of the same parts of the, something that's in the same part of the FAR is all going to be addressed with the same numbers to start with. So for instance, any clause that starts with FAR 52.222 something is going to relate to the application of labor laws to government acquisitions. So that's why you're going to hear me talk about FAR Part 22 and the FAR 52.222 clauses today. The last kind of level setting thing I'll note is that there is a law called the Federal Property and Administrative Services Act. Some people call this the Procurement Act, but this is a statute wherein Congress has given the president a fair bit of powers to deal with procurement. This is the law that has been underlying many executive orders, and it's what has resulted in a lot of executive orders that presidents issue related to government contracts. This is used very often by presidents to provide and encourage the American folks to follow labor and employment policies that they may not be able to have otherwise. This is the law that was used, for instance, for the vaccine mandate. And this is a law that we see being used to kind of make government contracts a bit of a petri dish for labor and employment policies that presidents want to have nationwide, but they can't really issue nationwide. So they do it through executive orders specific to government contractors. And that's what we'll see come up in a few of these later slides. Now, we'll start off talking kind of about big picture changes to labor and employment for government contractors, and then get a little more narrow, and then end with the updates or expectations for 2026. And I think the broadest thing we could start with, hopefully that you'll understand why I say that based on our introduction of the level setting, is the FAR Part 22 rewrite. So earlier this year, President Trump issued an executive order called Restoring Common Sense to Federal Procurement. This is an effort to return the FAR to its statutory roots, as the OFPPP is now stating, and to rewrite it in plain language and remove most non-statutory rules. So the idea is to rewrite the entire FAR. Some folks are calling this the RFO. That's a bit of an odd term to me, but I will call it that sometimes today, and I'll call it the overhaul. But this has been something that's been undertaken since the executive order was issued. And since that point in time, up through the end of the government fiscal year, which was September 30th, the FAR Council was busy rewriting each part of the FAR and rolling out the rewrite each on a milestone basis. It wasn't all at once. It came out piece by piece. The rewrite isn't just coming out as a rewrite. It is coming out as with a FAR companion guide, which is supposed to be guidance for contracting officers, and a practitioner album to help contracting officers further understand the rewrite. Because this has not gone through notice and comment yet, however, it is not an actual change to the FAR. Agencies have to adopt the rewrite through a deviation. So this revolutionary FAR overhaul has come out and started, but not all parts of it have been adopted by agencies yet. And only some agencies have adopted parts of it, and they haven't adopted all parts of it for the most part, which I know was a lot of parts referenced there, but hopefully this next slide may help clarify what has been happening, particularly for FAR Part 22. So again, this is the part of the FAR that is focused on labor laws applicable to government contractors. There are a few other parts of the FAR that pull in labor laws, but really the FAR Part 22 rewrite is the main one that's going to be relevant for government contractors who are dealing with labor and employment issues. This was something that the FAR Council worked on up until the last possible moment. They issued the rewrite on September 30th, 2025, so the last day of the fiscal year. Again, this is only effective, the rewrite is only effective for agencies if the agency has adopted a deviation, adopting the rewrite. It will become, potentially, the FAR Part 22 rewrite will become applicable to all agencies after it's gone through notice and comment procedures, but that has not even been started yet. So we're going to start seeing some piecemeal adoption of FAR Part 22, which means contractors who are dealing with labor and employment issues are going to start seeing some pretty disparate treatment of some of these FAR Part 22 questions for the next year or two until we get through notice and comment. At this point in time, or at least as of yesterday, there was no language in the companion guide on the FAR Part 22 rewrite, so there's still no guidance for contracting officers looking to implement the rewrite. But at this point, as of yesterday, at least, there was only USDA and GSA that had issued deviations implementing the rewrite. So right now, those are the only agencies that have adopted the revised version of FAR Part 22. And their adoption of this may change if notice and comment results in revisions to the rewrite. Some things that came about as part of this change or the revolutionary FAR overhaul rewrite, items were removed. Again, that was kind of getting at the whole purpose of this FAR Part 20 or the FAR overhaul is to remove items. Some of these items, some of these items have been identified for complete removal. Others are identified for removal to be put in guidance, like the companion guide. There's also, though, been some things added to the rewrite. So that's, I think, a little bit interesting from the perspective of folks, I think, had anticipated that the revisions would mean a complete shrinking and no additional items, but that's not really the case. There have been other items added as a result of the rewrite. There's also been changes made to a number of provisions and changes that weren't really explained as part of the rewrite. One thing that I identified just as an example of a change is a reduction in the threshold for requiring anti-human trafficking plans for certain contracts. That's something that changed as part of the rewrite. And I think for some folks, they may be surprised that some items that weren't required by statute or that are not required by statute have been maintained as part of FAR Part 22. So just because something isn't required by statute did not necessarily mean that it's been removed as part of FAR Part 22. So anybody who's dealing with the rewrite definitely wants to take a closer look at what the changes were. And this slide, I'm not going to spend a lot of time on, but I did want to give you an idea of some of the FAR Part 22 clauses and provisions that have been identified for removal. These are not necessarily going to be removed from any contract, but these are the ones that have been identified to not be included in future contracts at the very least. This list is not final and may change as a result of an agency deviation. It may change as a result of notice and comment. But this is a list of some of the contract clauses and solicitation provisions that the practitioner album at least has identified as not being included in future government contracts. And again, these are all clauses that relate to labor laws and labor requirements for government contractors. Now, we're getting into the heart of some of the true changes that have come up through this past fiscal year. And I think probably for most contractors, this is an update that had the biggest impact on their work, at least as far as labor and employment work goes, and what labor and employment folks had to address at government contractors. So at the very beginning of this administration, President Trump issued Executive Order 14173, and one of the big things that this executive order did was it rescinded Executive Order 11246. That executive order had been issued under what I mentioned earlier, the Procurement Act, or the Federal Property and Administrative Services Act. I have to look back. Yes. Federal Property and Administrative Services Act, which again shows you how that statute has been used by presidents in the past. But that executive order has existed since the 60s. And so this is a rollback and a fair change from what President Trump had done even in his first administration. So rescinded Executive Order 11246 and also directed agencies, OMB and OFCCP, to do certain things as a result of the executive order. One of the things that we'll be talking about more is this direction to agencies to include in contracts and grant awards a certification that the award recipient does not operate any programs promoting DEI that violate federal anti-discrimination laws. And also ensure that compliance with federal anti-discrimination laws is material to payment under the False Claims Act. Another thing that we'll talk about in this session is OFCCP and the changes to that as part of this executive order, which is on the far right side of the screen. But one of the main things to keep in mind there is that OFCCP is the part of the U.S. Department of Labor that has traditionally had enforcement authority over EO 11246, which again was rescinded as part of this new Trump executive order. And so the big kind of deal for contractors from this executive order is that now there's a couple of kinds of liability for contractors who may have anti-discrimination issues within the workforce. So I will say that certain anti-discrimination issues already were starting to come up following the Students for Fair Admissions decision from the Supreme Court in 2023. I know that decision did not deal with employment law at all, but DEI programs, and particularly federally funded programs, were already under the microscope and were facing lawsuits related to their activities. That problem still exists. That possibility of liability still exists today. And that's something that I think a lot of contractors and public entities have in the back of their minds as something they're taking into consideration when they're looking at their DEI programs and changes to them. But what this executive order also did was create this possibility of False Claims Act liability. And that's going to be potentially higher stakes liability for a number of contractors. And it also increases the scope of who might be able to bring a lawsuit. So not only might the financial stakes be higher under a False Claims Act lawsuit, but there's other people who might be able to bring a False Claims Act lawsuit than those who might typically be bringing the private lawsuits. And in particular, the False Claims Act allows what we call relators to bring a lawsuit, and that could be competitors, former employees, current employees, a number of different folks, and really anybody from the public could be a relator, but typically it's going to be those folks that I mentioned, former employees, current employees, or competitors that try to bring these lawsuits. There were a number of lawsuits filed against the administration after this executive order was issued in an effort to limit the application of the certification quickly. And there were some injunctions issued, but the long and short of it is that most agencies can seek certifications at this point, and it's the certifications that are relevant because that's what gives rise to the False Claims Act liability, is having a false certification that's made under the contract. And I will say before I move on that I understand that DOJ is starting to bring the first of these cases now. So it's something that we're starting to see at this point, and I do think we may see more of in fiscal year 2026, not to give away too much of what we might talk about later. Okay. So one of the other things I mentioned about this Executive Order 14173 is that it revoked the executive order from the 60s that we always referred to as 11246. But just because that executive order was revoked doesn't mean that the contract obligations were removed from contracts. Typically, when a contract clause is in a contract, the contractor has to continue to comply with that obligation unless and until the clause is removed from the contract. The Department of Labor, however, is not enforcing obligations. I have not been made aware yet of any contracting officer trying to enforce the obligations. So that has impacted, I think, how a number of contractors have approached the revocation of Executive Order 11246. I think another thing that has impacted how contractors are addressing the revocation is the fact that certain parts of the administration have heavily suggested that compliance with the FAR clause and the executive order is prohibited now because it was illegal. However, when you read things closely, you can tell that there's nothing that's per se illegal about complying with Executive Order 11246. The question, though, is how did a contractor actually implement its program, which included an affirmative action program as part of compliance? How was that implemented? And as the Office of Federal Contract Compliance Programs has noted, the current OFCCP has noted, a number of companies' implementation of Executive Order 11246 may have resulted in violations of anti-discrimination laws. So there could be things that contractors have had to change because they don't have the cover of protection of Executive Order 11246. And that is something we are seeing contractors taking a look at, is whether or not they had anything that would be considered illegal under the anti-discrimination laws. And we honestly have seen contractors take very different approaches in how they want to address this revocation of Executive Order 11246. And some of how they've made decisions has been based on a number of different things. But I note that there's a variety of approaches because I think contractors have had to take into account a number of different facts that may depend on their specific situation. And we have not seen kind of a one-size-fits-all approach to dealing with the revocation. So OFCCP, as you might remember from the earlier slides on this executive order, was directed to do certain things. One of the things that it was supposed to do was stop enforcement of Executive Order 11246 regulation. And they've already started to, they being OFCCP, has already started the rule notice and comment process to remove the Executive Order 11246 regulations from the Department of Labor enforcement side of things. Not going to spend much more time on it, but really the key thing to keep in mind is that OFCCP has started the process to remove certain regulations related to Executive Order 11246. OFCCP has also changed its approach to enforcement because of the executive order. Shortly after the executive order was issued, within days of that, the Department of Labor, the secretary from the Department of Labor, or at least acting secretary, had issued an order that ordered OFCCP to stop all investigative and enforcement activity related to the prior executive order 11246. That order also put on hold all other OFCCP enforcement activity for other things that it has purview over beyond Executive Order 11246. So that's the Section 503 of the Rehabilitation Act, which deals with discrimination against persons with disabilities, and VEVRA, so the Vietnam Era Veterans Readjustment Assistance Act, which deals with discrimination related to veterans. So those were put on hold in late January. And it took until early July for Department of Labor to lift that order and allow OFCCP to start enforcement activity again under Section 503 in VEVRA. From what I hear, there's still not a lot of enforcement activity related to those areas, but we are starting to see at least that OFCCP has taken the position that it will be enforcing those obligations. OFCCP also in June issued a letter to contractors essentially inviting them to tell OFCCP how they are winding down their Executive Order 11246 programs. I've quoted some of the language from the letter that was sent to contractors, not really something I'm gonna go through because it's unclear what, if any, benefit there actually was going to be to contractors for providing this information. OFCCP doesn't have enforcement capabilities over Executive Order 11246. So it really provided, this letter didn't really indicate any benefit that contractors were going to have to providing this. There also is some clear, I think, drawbacks to providing this information to an agency that is winding down enforcement activities. One is that there was nothing in the letter that indicated that the agency was going to protect the information under FOIA. So the information that was provided could be obtained via FOIA and used by somebody from the public who was trying to later bring a False Claims Act action. So clear drawbacks from this, but it is something that OFCCP offered up to contractors, and they gave contractors 90 days to provide a response, and that period has now passed. But I think one of the other things to me of why there didn't seem to be much benefit to providing the information is that really OFCCP, because of its lack of enforcement capability right now on these issues, is that they're not the concern. Really, the concern is going to be relators and the Department of Justice and how they might use this information. So for folks that may be considering providing this information later, it's still not something I see really any benefit to doing. So that's kind of where we're going to end the discussion on Executive Order 14173. So before we move on, we wanted to give today's first secret word. Please go ahead and select the correct word from the list below, and I'll give you a couple minutes to do that before I move on to one of the other big topics, which is the $15 contractor minimum wage. All right, I'll give 5 more seconds. Okay, next we'll talk about the $15 contractor minimum wage. And we'll be tying back in some of the earlier level setting discussion. And hopefully you'll see why I thought that was helpful as we get further into our review of where this regulation and requirement stands. And Before we get into what happened in fiscal year 2025, I thought it'd be helpful to go over what happened before this fiscal year and set us up for why some of these changes may have happened and what we're looking at. But big thing is that in 2014, President Obama issued an executive order establishing a minimum wage for government contractors, setting it at a higher level than the regular federal minimum wage. And this was issued under, not surprisingly, the FPASA, the Procurement Act that we've been talking about. And this is something that was implemented in contracts via a FAR clause numbered 52-222-55. When President Trump first had his first administration, he did not revoke that Obama executive order. He did make some changes to the contracts that it applied to and a couple of other small changes, but largely left the Obama executive order in place. When President Biden came in 2021, he issued a new executive order raising that minimum wage, hiking it up to $15 an hour as of January 30th of the next year, and calling for annual increases each year under that. As of January 1 of 2025, that contractor minimum wage is $17.75. The Biden executive order, I will note, also did expand the scope of covered contracts, so expanded it beyond what President Obama had initially included, and rescinded some of the exceptions that President Trump had issued during his administration. I will say, note that the executive orders didn't fully, neither the Trump executive order that came in between Obama and Biden, nor the Biden executive order changed really the Obama executive order as applicable to contracts that already had FAR 52-222-55 prior to those changes, which means there are still some contracts being performed today that may be subject to the Obama executive order, and that minimum wage is currently at $13.30, and that's what it's been at since January 1st of this year. So background is we've got a couple of executive orders establishing contractor minimum wages. The Biden executive order pushed it up to $15 an hour, but really it's higher than that at this point in time. After the Biden executive order was issued, there were numerous challenges brought against it, and brought against not just the executive order, but the Department of Labor's implementation of it. There were some limited injunctions issued. They had various scopes in the applicability of those injunctions, but generally speaking, the $15 minimum wage was allowed to carry on for many, many government contractors. The cases have not come to any final decisions as of the last time I looked. So there were, the pre-2025 background is keeping in mind that there were multiple executive orders and there were challenges in courts, but nothing that actually rolled back the minimum wage requirements for all contractors. And that's what takes us to the President Trump executive order relating to the $15 minimum wage. In March, President Trump issued another executive order to that rescinded a number of prior executive actions. It listed 17 other executive actions that, or I'm sorry, 17 total executive actions that were rescinded as part of this Trump executive order, one of which was the Biden executive order. So the executive order 14026. Because this was an executive order by President Trump that rolled back a number of items, it didn't provide details on the rollback. So it didn't provide any statement to agencies about how they should be rescinding Executive Order 14026. And it also didn't address the Obama executive order, so Executive Order 13658. So there have been a number of open questions as to what this means for contractors. But I think it's fair to say that the federal minimum wage requirement for government contractors is probably not being included in solicitations or contracts at this point. It may still find its way in there, but for the most part, what we've been seeing is that it's not being added to new contracts or solicitations. We also know that the Department of Labor has issued guidance on its website about this, but it's not really guidance. And I say that because really the Department of Labor has just said that it is not enforcing the minimum wage executive order, the Biden minimum wage executive order, or the implementing regulation, and that it's going to take steps to rescind it. It has not done that yet, though. Unlike what we saw with the other executive order involving Executive Order 11246 and affirmative action programs, the Department of Labor has not started the notice and comment process to revoke these regulations just yet. Adding some complications to this is the fact that the FAR Part 22 rewrite maintains language about the applicability of both the Obama and Biden minimum wage executive orders. So right now, even the FAR rewrite, even the FAR deviations are requiring compliance with these executive orders. Also, if you recall from the slide of clauses that have been identified for removal, the practitioner album has not identified the relevant FAR clause, which is 222-55, as one for being identified for removal. So there are still some contracting officers who very well may try to include this clause in future contracts. So that's why you'll see on the first bullet, I say this requirement may no longer be added into solicitations or contracts, but it also may actually be added. So it's something to look for as contractors are bidding on new projects to see what's there. I will also note that the practitioner album for the FAR Part 22 rewrite specifically notes that the deviation text doesn't cover the revocation of the Biden executive order. It never references the Obama executive order. And all it does is refer back to that Department of Labor website that notes that there's going to be a revocation of regulations coming in the future. So still, right now, the Department of Labor and the FAR Council has not made it perfectly clear how contractors and contracting officers really need to be addressing the change in the $15 minimum wage requirement. And ultimately, that means that this may not impact a number of contractors because right now, contractors who have FAR 52, 222, 55 obligations in their contracts are still contractually obligated to comply with what's required by that clause. And so a contracting agency could still take an enforcement action against the contractor if the contractor doesn't pay the required minimum wage, even if the Department of Labor doesn't take an enforcement action. There's a number of reasons why a contracting agency may want to take those enforcement actions. And we talked about those in an article that we issued shortly after the revocation came out. But essentially, the big thing to keep in mind for contractors is the contracting officer may want to enforce it when it's going to impact performance of the contract, or if it's going to result in any undue profit for the contractor. So there is still a contractual obligation to provide this minimum wage if the clause is in the contract. Additionally, a number of contractor employees could be under federal, state, or local minimum wage laws that don't really impact or that minimize the impact of the revocation of the Biden executive order. Additionally, state laws may require contractors to pay wages as required by law or contract. So we have seen in other instances, employees try to bring lawsuits against contractors for failing to pay required wages. That is something we could see potentially happening here, is that contractor employees may try to enforce this requirement under their state laws. And another way this could come up is under a state or local jurisdiction that requires something like advance notice or prohibits reducing pay. So long and short of it is contractors may have their hands tied as far as reducing pay where they've been obligated to provide this contractor minimum wage of $17.75. So even if the federal government, from the Department of Labor perspective, may not be enforcing this, contractors may still have some reason that they need to continue to pay the $17.75 or whatever it is under their contract. The next thing we'll talk about is more about wages. This is specific to construction contractors. It's the Davis-Bacon Act revisions. These revisions came out in 2023, so obviously not a new rule, not something that came out in fiscal year 2025. But back in those changes that occurred in 2023, there were a number of changes that involved things that contractors didn't love. And some of these changes included a change to the process and the data that would be used for determining prevailing wages. Another thing that was, I think, viewed as very problematic to contractors is the fact that the regulations stated that the contract clauses and wage determinations would apply to a contract by operation of law, even if they weren't part of the contract. So it really was making a contractor subject to contract obligations that the contractors didn't have notice of. And unsurprisingly, there were a number of challenges to these changes to the Davis-Bacon Act regulations, or I should say the revisions to those regulations. And those challenges are still waiting for decisions. We saw that there were a couple of cases filed in Texas. The motions for summary judgment are pending, but those cases have been stayed for a little bit now. We may not get a decision during any time in the next few months, but that may be something that we will hear. And really the takeaway for what happened in fiscal year 2025 is that injunctions that had been issued are still in place, and they do prohibit a number of revisions to the Davis-Bacon Act regulations from being enforced. And one of the things that's currently enjoined is the application by operation of law. And I note these things mostly because if you are a contractor and the government is trying to take enforcement activity because of these revisions, you really should talk with your attorney and check to make sure what the issue is for enforcement and if that's something that is currently covered by an injunction. Another issue that has come up that's specific to construction is the use of project labor agreements. This is something that started under the the Biden administration as well. This was an executive order issued by President Biden, and it required project labor agreements for large-scale construction projects. And a project labor agreement under the applicable part of the FAR Part 22, is a pre-hire collective bargaining agreement with one or more labor organizations that establishes the terms and conditions of employment for a specific construction project and is an agreement described in 29 USC 158F. So under President Biden's administration, he started requiring agencies to use these project labor agreements on large-scale construction projects. Also permitted agencies to require project labor agreements on non-large-scale projects if the contracting officer thought it was appropriate. So required for some construction projects, permitted for others. And this was implemented through FAR 52-222-34, which is a clause about project labor agreements. Then in fiscal year 2025, we saw kind of a wave of trying to understand what this meant in the new administration. And takeaway is really that project labor agreements were gone in some instances, but now they appear to be here for to stay potentially, because what we saw was early in the Trump administration, some agencies, in particular the Department of Defense and GSA, issued some deviations directing contracting officers not to use project labor agreements on certain types of construction projects. We saw a union bring a lawsuit and shortly thereafter, a few months thereafter, challenging these deviations. A court set them aside, and we thought we might see the litigation play out. But lo and behold, the administration made it clear that they support the use of project labor agreements and that the deviations should not be considered. Agencies should not be issuing these deviations. And but I will say the administration did note that there could be an exception made if the requirement for project labor agreements would inhibit competition. So the administration said, agencies, you don't have to require it if it's going to impact competition for the project, but generally we're going to follow what the Biden administration required and also require the use of project labor agreements. We've also seen the Trump administration continue to defend the project labor agreements in court. And we saw that the FAR Part 22 rewrite maintained compliance with the Biden executive order. So safe to say that these project labor agreement requirements have survived through a Democrat administration and a Republican administration, and that may mean that we'll see this requirement continue on for quite a while, given that there seems to be bipartisan support. So the last, before we get to the last topic of what happened in 2025, we'll give the second secret word, and that word is protest. So I'll give you a few seconds to select the appropriate word, and then we'll talk about some protest decisions. All right, I'll give 5 more seconds. Okay, so the last thing we'll talk about before we end with what to expect in 2026 are some of the bid protest decisions. So the first thing I'll mention is that one of the protest decisions suggested that contractors are not going to be able to protest contract clauses violating labor laws. There was a GAO decision where it sustained in part and denied in part a protest that challenged the inclusion of a labor harmony agreement. The protester had argued that the agreement was preempted by a number of laws, including National Labor Relations Act. Uh, the GAO said, we're not going to consider any violation of those laws because a violation of those laws is outside of our jurisdiction and is not something that's contemplated for us to consider under CICA, the Competition and Contracting Act. I know some government contracts attorneys who disagree with GAO's stance and that feel that GAO has made decisions in the past where a law may not have been or may have been considered in this way. So it will be interesting to see how this plays out. But at this point in time, GAO seems to be taking the position that it's not going to consider protests if you're alleging that a contract clause requires the contractor to violate labor laws. Another item that came out of protests this year is that when a key person departs, that could limit protest options. Essentially, the GAO held for the first time, but held it in multiple decisions, that if an offeror's key personnel departs after proposal submission, but before award notification, that entity does not have standing to bring a protest at the GAO. So that's something that potential protesters really need to pay attention to. Obviously, before award is made, you don't know if you're going to be the awardee or the protestor, but it is something to keep in mind. It will also affect your ability to maintain the award as an awardee. And so this is a decision that's really pushing contractors to notify agencies of departures for key personnel if you want to go to the GAO, which I note that because we have been seeing more of an effort to go to the Court of Federal Claims for protests, and this is another reason why contractors may end up doing that. And the last bid protest decision I'll note, and it's actually not one decision I should note, is that there were a lot of bid protests involving professional compensation plans this year. And contractors really, I think, are going to start paying attention to this. And it's something that protesters are really paying attention to. So I think the takeaway for me here is when a solicitation involves professional compensation, whether or not a plan is required, it's something that offerors really want to pay attention to. And the last thing I'll mention is what I expect in fiscal year 2026. But any questions that you all have, please put them in the chat and I'll try to answer those before we head out for the day. But what I expect to be happening between now and September 30th of 2026, I think we'll see the notice and comment rulemaking process start for the FAR Part 22 rewrite. I don't know that we'll see it conclude, but I think we'll see that happen. So anybody who wants to provide commentary on this FAR Part 22 rewrite certainly wants to gather their thoughts now. You can make comments on the deviations right now up until November 3rd, I believe, but also during the notice and comment period. I think we'll also see some more guidance coming out on the FAR Part 22 rewrite. So that's the FAR part or the FAR companion. I think we'll also see some of the DEI certifications become consistent. So those certifications coming out as a result of Executive Order 1473, I think we'll start to see more consistency there. I think we'll also start to see some lawsuits come to completion, which may also provide some guidance for contractors. And I think the last thing that I'll note is because of all of the government reductions in force that we saw this past year, a lot of government employees went to the private sector. And a lot of folks who weren't used to hiring government employees were bringing in government employees for the first time. And so I do think we are going to see some enforcement activity related to that, because there are a number of statutes and regulations that govern the hiring of former government employees. So I think for contractors, we'll see some bid protests come out. I think we might also see some trade secret suits coming up between competitors, where somebody who left the government is providing information about competitors to their new employer. And I think we're going to see some other enforcement mechanisms come up this year, because I do think, given the huge influx of these folks to the private sector, there's just going to be a number of items that come up. But that's my predictions for the future. Who knows if this is actually going to come to fruition? I truly do think, though, these are all things that we will see. But if you have questions, again, please feel free to put them in the Q&A widget. But otherwise, thank you for participating in our webinar today. Please also complete and submit the survey that's going to display at the conclusion of the webinar.